So, we'll discuss about Council of Ministers as provided under Article 74 of the Constitution of India. So, while discussing Council of Ministers, it is well known that Council of Ministers is a part of parliamentary form of government. So, the very origin and development of parliamentary form of government, if you would trace its origin, then it was originated from United Kingdom or Great Britain and Belgium. And in ancient civilization, we found the traces of parliamentary system in the ancient Egyptian civilizations, also in Mesopotamian civilization, but to its very medieval origin that we found in 1295, King Edward I called the Great Council. So it was the first form of parliamentary system that developed and arisen from England in 1295. But exactly in the modern sense, parliamentary system was originated in 1616, and it was due to Charles I who originated and developed a cabinet council in 1625, and that cabinet council took in the form of a privy council first. Then in turn in 1644 that privy council, which was formed by Charles I, then it was taken the form of a cabinet, and so the very form of cabinet system or cabinet council, which was originated in 1625, then it took the form of privy council, and that privy council then subsequently took the form of cabinet in 1644, and ultimately that was the very origin of Council of Ministers. So, as India, after its independence in the framing of Constitution for India, adopted parliamentary form of government, also cabinet or collective responsibility of the Council of Ministers, and as accordingly under Article 74 of the Constitution, there was the provision regarding a council of ministers, and that council of ministers is to aid and advise the president, and the aid and advice of the president. Why the council of ministers, or generally or otherwise the president, shall act in accordance with the advice of the Council of Ministers if it is being tendered even after any consideration expression for which the presidents and the head and advice of the Council of Ministers to reconsider, and after such consideration, the President is bound to act according to the aid and advice of the Council of Ministers as it is inserted under Constitution 44th Amendment of 1978, and the very advice of the Council of Ministers to the best President shall not be inquired into in any court as it is provided under Article 74 of the Constitution. So, in relation to that, we would like to discuss some important leading cases such as Shamsher Singh versus State of Punjab in 1974. So also another case, that is Union of India versus V. Sri Haran in 2015. The Supreme Court expressed that under Article 74, the exercise of the functions of the President should always be based on the aid and advice of the Council of Ministers, headed by the Prime Minister. Under the provision to the said article, the President can at best seek for reconsideration of any such advice and should act based on such reconsidered advice. So also Article 74 Clause 2 in fact has insulated any such advice being inquired into by any court. So also identical provisions are contained in Articles 154, 161 and 163 of the Constitution relating to the governor of the state. Reading the above provisions, it is clear that the President of the Union and the Governor of the state, while functioning as the executive head of the respective bodies, only have to act based on the advice of the Council of Ministers of the Union or state, as it was observed by the apex court in the leading case Union of India versus V. Sri Haran, and in Shamsher Singh versus State of Punjab, it was observed that by the provisions of Article 74 Clause 1, as it now stands after the 42nd and 44th constitutional amendments, the President is bound in every case to act on the advice of the Cabinet. The amendment incorporates the view taken. So, this was the pronouncement of the Supreme Court in this leading case, Shamsher Singh versus State of Punjab in 1974. So, the very prerogative of the crowns, as we found under the British parliamentary system, where the Crown's prerogative regarding the dissolution of the House of Commons and consequently Crown's prerogative was limited as due to the adoption of parliamentary system of government where the House of Commons as the popular chamber or the lower house of parliament got the absolute right regarding dissolution of the parliament as the very government that is formed majorly constitutes the majority party which got majority in the House of Commons it formed the government, so the Prime Minister and the Council of Ministers in majority they belong to the House of Commons, so as it is a popular chamber elected by the people, so now Crown does not enjoy that prerogative regarding dissolution of the House of Commons. Now it is quietly depend on the Council of Ministers to aid and advise regarding the very dissolution of the House of Commons and the same provisions as we found under Indian Constitution. So now we will discuss regarding confidentiality of cabinet decision, and in regards to that we will discuss the very important leading case Kartar Singh versus State of Punjab, which was decided in 1994, where it was held that courts are justified in looking into the basis of the advice subject to the provisions of Section 123 of the Evidence Act as it was pronounced by the Supreme Court in the leading case Kartar Singh versus State of Punjab in 1994, and as regarding the very relationship between Article 74 and Article 163 and the governor's discretionary power, we would like to discuss another important leading case, and that is State of Gujarat versus Justice retired R.A. Mehta in 2013. Supreme Court expressed that there is a marked distinction between the provisions of Article 163 and 74 of the Constitution. The provisions of Article 74 are not in perimeteria with the provisions of Article 163 of the Constitution, as Article 74 provides that there shall be a Council of Ministers with the Prime Minister at the aid and advise the President, who shall, in the exercise of his function, act in accordance with such advice as is rendered to him, provided that the President may require the Council of Ministers to reconsider such advice either generally or otherwise, and the President shall act in accordance with the advice that is tendered after such reconsideration. While Article 163 of the Constitution provides that there shall be a council of ministers with the chief minister at the head to aid and advise the governor in the exercise of his function. An exception has been carved out with respect to the situation wherein he is by or under this constitution required to perform certain functions by exercising his own discretion, as it was pronounced by the Supreme Court while making a comparison between the power of the president and the power of a governor of a state as regards to accepting the aid and advice tendered by the Council of Ministers under the head as Prime Minister in case under Article 74 of the Constitution and as in case under Article 163, the very aid and advice tendered by the Chief Minister and the Council of Ministers to the Governor, where the Governor has the prerogative of exercising discretionary power as it was pronounced by our Supreme Court in 2013 in the most important leading case, State of Gujarat versus retired Justice R.S. Mehta in 2013. And now we'll discuss the very 91st Constitutional Amendment Act 2013, which provided under Article 75, Clause 1A, as regarding the very provision that the Council of Ministers shall constitute only 15% of the total members of the House of the People, as it was inserted under 91st Constitutional Amendment Act 2003 as under Article 15 Clause 1. And another thing that we found under Clause 2, that the Council of Ministers headed by the Prime Minister, and as regarding the very continuity of the Council of Ministers almost depends on the pleasure of the President of India. And as regarding Clause 3, the Council of Ministers, headed by the Prime Minister, would be collectively responsible to the House of People or the Parliament. And as regarding Clause 1B, that we found in relation to disqualification, and as such disqualification under the 10th schedule, and that 10th schedule was inserted under the 52nd Constitutional Amendment Act in 1985, which deals with disqualification of members in regarding to defection. So it is a kind of anti-defection law under which a member of parliament could be declared as disqualified by the Speaker of the House of People, and in relation to collective responsibility, we would like to discuss the very important leading case relating to collective responsibility is the leading case State of Karnataka versus Union of India, which was decided in 1978 by the Supreme Court, where it laid down the very object of collective responsibility. And the object of collective responsibility, as pronounced by the Supreme Court in 1978, in this particular leading case, State of Karnataka versus Union of India, is to make the whole body of persons holding ministerial office collectively, or if one may so put it, vicariously responsible for such acts of the others as are referable to their collective violation, so that even if an individual may not be personally responsible for it, yet he will be deemed to share the responsibility with those who may have actually committed some wrong. So, this is the very principle of collective responsibility and the very object of collective responsibility as it was pronounced by the Supreme Court in this important leading case, State of Karnataka versus Union of India in 1978, regarding the very object of collective responsibility. So, in our next video, we would like to discuss another important aspect of the Constitution of India, and that is relating to disqualification of members of Parliament